Evidence law, hearsay. We're going to start with the hearsay elements. It's out of court statement given for the truth of the matter asserted. So get into hearsay. Three elements of hearsay. Out of court statement for the truth of the matter asserted. Remember that hearsay is still subject to 403 balancing. If a hearsay statement can get in under a rule, but it's highly prejudicial, then it still might not pass 403 balancing. Just remember that. So out of court, self-explanatory. It's referencing something that's not being said at the present moment in the court, like for testimony. Statements. Sometimes nonverbal assertions can be a statement. Example, Princess Diana shaking hands with an HIV positive patient, since it was purely for messaging communications. But if I, Ross, just privately shake hands with a friend who happens to be HIV positive, that's probably not an assertion or a statement. An example, sitting on a curb sobbing after a car accident isn't a statement. It says sobbing isn't a statement. You're just having emotions. You're not trying to communicate anything. Note, FRE 801C only applies to people. So police dog barking when it smells drugs is not a statement for hearsay purposes, since only people can make statements for 801C purposes. With that in mind, most evidence scholars think the AI or ChatGPT won't be hearsay since it's not a person. Important. It's impossible for situations where silence. It's possible for situations where silence could be an assertion. For example, someone makes a wild accusation against you killing someone, and you just sit there silently. A normal person would refute that statement, but your silence is kind of communicating, yeah, I did it. Some interesting French cases. Audio tapes. Audio tapes consider statements made by someone not declaring it in court, and it's a recording of an out-of-court statement. Photographs or videotapes. Most photographs and videos don't contain assertions. Instead, they usually depict physical objects or non-assertive human conduct. Machine recordings. Automated machines like polygraphs and breathalyzers or radar guns, they're not making statements, so they're just numbers reported by a breathalyzer. That's not hearsay, it's a mechanical process. But sometimes the machine conveys a human assertion, like a bank teller pressing a panic button is a human assertion that there is an emergency. That would be a statement. What evidence consists of information conveyed by the machine? The judge will explore whether that information incorporates a human assertion. If a person communicated a fact through a machine, then the assertion is a statement subject to the hearsay rule. If the machine just generates information according to its own internal processes based just on inputs, then the machine output is not an assertion by a person. This policy makes sense because machines don't lie. They might not be accurate, and parties are completely free to attack the machine for being inaccurate or malfunctioned or sabotage or whatever, but the machine itself doesn't consciously decide to lie. So we need the assurance of a courtroom appearance and cross-examination only when the information transmitted by a machine originated with a human decision maker. Next, we'll talk about TOMA, truth of the matter asserted. Good test for whether something is for TOMA. Ask if the declarant is wrong about the underlying fact. Will the jury be misled? If yes, then it's hearsay. If no, then it's not hearsay. It's TOMA, or no, then it's not TOMA. Please note the four common non-TOMA purposes that we'll try to get tricked on the final. So first, knowledge or notice. Two, verbal act with independent legal significance, like language that creates conspiracy, language that creates a contract, like saying I accept, or language that's a threat. That has independent legal significance. It's a verbal act. That would be non-TOMA purposes. If you said, and then Bob said to me, I accept your contract. It's a verbal act, it's independent legal significance. You can use it to show that there was a contract, not because it shows the truth of the matter asserted, but because there's an independent legal significance of Bob saying the words, I accept. Effect on the listener. I have a knife. I have a knife made the victim think the perpetrator had the knife. Oh, look, the person has a gun, causes everyone to run out of the room, right? That's just effects on the listeners. It wouldn't actually show that the person actually had the gun. Also, you can use it for impeachment. Those four exceptions aren't specifically mentioned in the rule. It's just a concept that comes up a lot. These concepts are times when a statement is made not for the truth of the matter asserted. So, just repeat it 5 times. These four exceptions aren't specifically mentioned in the rule. It's just a concept that comes up a lot. These concepts are times when the statement is not made for the truth of the matter asserted. Again, knowledge or notice, verbal act, effect on the listener, or impeachment. Knowledge or notice, verbal act, effect on the listener, impeachment. Knowledge or notice, verbal act, effect on the listener, or impeachment. Those are the 5 times. For now, first we'll talk about knowledge and notice. Example, an employee says to Jim, man, that banana peel has been on the floor for like 3 days now. Jim then slips on the peel and sues the store. The store could introduce the employee's statement, since it's not for the truth of the matter asserted to prove the banana was actually there. Rather, it's being introduced to show that Jim had noticed that the banana was here. Thus, the store should not be liable for his slip and fall. Example, self-defense. Alan at bar said, quote, let me finish this beer. I'm going to take this knife and stab you with it. Let me finish this beer, and then I'm going to take a knife and stab you with it. Brett then stabs Alan in self-defense. Brett can introduce Alan's statement and it wouldn't be hearsay. That's because Brett isn't introducing Alan's statement for the truth of the matter. So he's not trying to say Alan actually was about to stab him. Rather, he's just introducing it to show Brett had noticed that he was about to be attacked. That gives him the ability to do self-defense and acted in accordance with that notice. When Alan was actually going to stab Brett, whether or not Alan was actually going to stab Brett, that's irrelevant. All we care about is that Brett heard Alan say he was going to do it and then thought he was actually being serious. Verbal acts. Some examples. Defamation. Whether contract was formed, like I accept, or whether conspiracy was formed. Next, talk about effect on the listener. Something caused the defendant to attack the victim. Here, a third person said, "The victim just attacked me." When we were talking about what caused a person to take action, it gets the effect on the listener rather than the truth of the matter asserted. Impeachment. Hypo. Ross says to Kim, "I was texting on my phone and I got in a car accident." Ross then later testifies in court, "I was texting when the accident happened," and the other party introduces my out-of-court statement to Kim saying, "I was texting." Rule. Introducing past inconsistent statements purely to impeach, then it's not hearsay. But what if you're trying to get in the content itself, i.e. you want to prove the witness as actually texting? Well, then that's not hearsay because you're trying to assert the truth of the matter asserted of a person texting and driving. So next we get to defined not hearsay. This is going to be 801, specifically 801D1 and 801D2. So this is defined not hearsay. That's where we're at. 801D1. It'd be prior statements by witnesses. Under 801D1 inquiry, a witness statement is, for now, exempt from a hearsay ban if the statement satisfies these conditions. The declarant must testify at trial, and the declarant must be subject to cross-examination on the statement. 801D1A, prior inconsistent statement. Under 801D1A, witness statement is exempt from the hearsay ban if the statement fits these three conditions. 1, the statement is inconsistent with the witness's current testimony. 2, it is made under penalty of perjury. And 3, it occurred at a deposition, trial, hearing, or other proceeding. Note, invocation of right against self-incrimination makes you not subject to cross-examination. But not remembering, whether you're faking or you actually don't have the memory, means you are subject to cross-examination for 801D1A purposes. So, witness statement is exempt from the hearsay ban if the statement fits under these three conditions. The statement is inconsistent with the witness's current testimony, was made under penalty of perjury, and it occurred at a deposition, trial, or hearing, or other proceeding. Note, invocating of the right against self-incrimination makes you not subject to cross-examination. When the statement is exempt from a hearsay ban if the statement fits these. It was made under penalty, it occurred at a deposition. Right. So to recap, witness invoking a right against self-incrimination, that makes them not subject to cross-examination. Can't use 801D1A to introduce a prior inconsistent statement in that case. You can't remember or claiming to not remember, that's subject to cross-examination, can use 801D1A to introduce a prior inconsistent statement. D1 is these two preliminary threshold questions. 801D1B, prior consistent statement. Under FRE 801D1B, witness statement is exempt from hearsay ban if the past statement is consistent with this statement and it fits one of the two conditions. Introduction of the past consistent statement is to rebut an accusation that witness is acting under improper influence or motivation, or to rehabilitate the declarant's credibility as a witness when attacked. Important note, a prior consistent statement, 801D1B, doesn't have to take place under penalty of perjury though. So, hypo, 1989, custody dispute between father and mother. An incentive for the mother to lie arose during this custody dispute. 1990, victim discloses abuse to several people, including the mother. 92, father D accused the mother of fabricating allegations. Here, the mother might want to bring up the mother's past consistent statements, 801D1B2. Mother White might want to bring in statements from 1990, right, when that happened. But the mother wouldn't be allowed to do this here. The rule is that the mother can only introduce the past disclosure, consistent statement, if it was said before the incentive to lie took place. But here, the disclosure, the consistent statement, took place in 1990, after the 1989 incentive to lie arose. Thus, the mother could not introduce the 1990 statement as a consistent statement in 801D1B2. Because, right, 1989, incentive arose, 1990, you start making statements, of course you have a thing to lie, and you can't come back 2 years later and say, see, I have past consistent statements from 1990. No, the incentive to lie arose before then. man. Rule statement. The rule for 801 D1 B12 is that the person introducing the past consistent statement must introduce a consistent statement that took place before the incentive to lie arose. Consistent statements that took place after incentive to lie arose would not be admissible as a consistent statement for 801 D1 B2 purposes. 801 D1C purposes. Prior identification statement. Under 801 D1C, witness's statement is exempt from hearsay ban if the statement was to identify a person as someone the declarant perceived earlier. Note, nothing in 801 D1C says you have to ask the same witness that made the prior statement. So you could ask the defendant, isn't it true that the witness identified you in the police lineup? That would be permissible. You don't necessarily have to ask witness X about the past police lineup. You can ask someone else. Interesting. So you can ask the defendant, isn't it true that the witness X identified you in the police lineup? Good to know. All right. Now we get to 801 D2. This is going to be party opponent statements? Okay. 801 D2. And that's going to get broken up into co-conspirators and multiple parties, I think. So just know that. So 801 D2, party opponent statements. A statement is now in court being offered against an opposing party, regardless of the opposing party's intention at the time they made the statement, is excluded from hearsay prohibition. 801 D2 lists 5 times when this exclusion applies. A. When made by a party in personal representative capacity. 2. Is one manifested or adopted or believed to be true. C. Was made by a person authorized to make a statement on that subject. D. Was made by a party's employee or agent within the scope of that employee-agent relationship. Or was made by a party co-conspirator in furtherance of the conspiracy. A statement can't be adopted by silence if you, the listener, would normally respond to the statement. The statement can be, quote, adopted by silence. Go back here. One manifest or adopted believed to be true. Adopted by silence if you, the listener, would normally respond to the statement. So if Jordan said to Todd, I hear you shot Jay Willie, and Todd just blankly stares at Jordan and doesn't respond, Todd said to, quote, adopt the statement by silence. There's a circuit split, though. One exception to adopting by silence: in some jurisdictions, a criminal suspect can not adopt a statement by silence when talking to the police or investigator once the criminal defendant suspect has been Mirandized. That's because Miranda says you have the right to remain silent and not implicate yourself criminally. The circuit split. Another way to adopt a statement: in some jurisdictions, if you adopt the person generally, say X is a reliable person and I know what he's talking about, then some courts say that's enough to mean you adopted everything the person says. Other courts say you need to adopt specific statements. Going back to E, was made by the party's co-conspirator in furtherance of a conspiracy. I think we'll talk about that more later. See subsection below. Statement must fit 2 elements. Conspiracy must exist between D and the declarant, and the statement must be made in furtherance of that conspiracy. Important note that you didn't understand before class, you definitely understand now and aren't going to fuck it up on the final. We don't care about the opposing party's intention at the time they made the statement. All we care about now is that the party, Ross, is using the opponent, Brian's, statement against him now. You're going to say it again because you're not going to fuck it up on the final. You definitely understand this now. We don't care about the opposing party's intentions at the time they made the statement. We don't care what Brian's intention statement was on the recorded phone call. All we care about is that Ross now is in court using Brian's statement against him now. And it's not hearsay, gets in under the party opponent exception. Repeat it 5 times in the outlines. We're going to say it one more time. We don't care what the opposing party's intention was at the time the statement was made. All we care about now is that Ross is using Brian's own statement against him in court now, even if Brian didn't think that was what he was using it for at the time. We're just using Brian, party opponent's statement against him. But there's one wrinkle here. Criminal defendants don't have an opposing party. Contrary to what you might think, prosecutor, detective, police officer, or investigator, that's not an opposing party within the scope of 801D2. That's why Professor H doesn't like this rule, since it's disproportionate, allows prosecutor to use the defendant's statement against himself, but the defendant doesn't have an, quote, opposing party to use their statement on 801D2. Remember for the last sentence of 801D2, C through E, that the judge needs something independent of the statement to establish conspiracy or employer-employee relationship for D2 or authorization, right? You need something independent to establish these 3. Co-conspirators, 801 D2E. In order to get a party opponent statement in is not hearsay, these requirements must exist. Remember, 1, conspiracy must exist between the defendant and the declarant, and the statement must be in furtherance of that conspiracy. Doesn't need to be charged as a criminal conspiracy. In fact, prosecutor doesn't even need to show a criminal conspiracy happened. All it needs to show is that the parties conspired together. Statement must be made in furtherance of that conspiracy. This means that just bragging about the crime to someone isn't in furtherance of the conspiracy. The rule is that bragging to a third party about your crime or bragging and confessing to a friend is not in furtherance of the conspiracy and thus not within the scope of 801 D2E. Also, the conspiracy ends for a co-conspirator when they are arrested. So the statement made to the police after they arrest definitely isn't in furtherance of the conspiracy. And the rule statement is theirs. The rule is that the statement to police that are not in furtherance of the conspiracy, so that the statements will not get in under the scope of 801 D2E. This is similar to how 801 D2D, an employer-employee agent, principal-principal relationship, must be in furtherance of that relationship and used against the employer-employee. So I guess here maybe look out for a statement where maybe the boss fires them and then the employee says something right after that. I guess look out for that. Important note on timing. Statement from before you join the conspiracy are still admissible against you in 801 D2E so long as you join the conspiracy at some point. So, important rule statement here. The rule is that once you join a conspiracy, any statement from the conspiracy, even before you join the conspiracy, can be used against the defendant under 801 D2E. So, for example, time 1. A meets with B to rob a gas station. They agree on a date and time. They're caught in camera saying, let's do it on June 2nd, 2 p.m. I'll get my friend C to be the getaway driver too. B approaches C for the first time to be part of the conspiracy. Remember, they already have a date and time planned. C's not part of the conspiracy yet. But now, at time 2, C agrees to be the getaway driver. At time 3, C is arrested and tried for his role in the robbery. Here, B's statement is admissible as a party opponent statement under 801. Party opponent statement under 801 D2E, even though it was made before C joins the conspiracy. That's because once C joins the conspiracy, then any statements in further of that conspiracy can get in against C under 801 D2E. What if you have multiple parties? General rule, parties' own statements can be used against that party only, not co-parties. So how do we get around this? In civil cases, just redact the other party's names, but in criminal cases, it's a little more complicated. You have 3 options. 1, you can redact the other side's name. 2, you can sever the trials. Or 3, don't use a statement. Now we're talking about Burton, Richardson, and Gray. We get these guidelines in situations where one criminal defendant makes a statement to law enforcement that implicates a co-defendant. A statement that explicitly names a co-defendant and implicates that co-defendant on its face violate Burton. Gray held that a statement that simply replaces the co-defendant's name with blanks or other obvious marks or deletion also violates Burton. Richardson held that statements by a defendant that does not refer to a co-defendant and that contains no obvious omissions tempting the jury to fill in the gaps, that satisfies Burton. The plaintiff can admit the statement, but it's only admissible against the defendant that made the statement, and the judge can give a limiting instruction to not consider against the co-defendant. Note that all of this only applies when these things happen. 1, the criminal defendants are tried jointly, and 2, one defendant made an out-of-court statement fails to take the stand that implicates the co-defendant. So you don't satisfy these 2 things, and you won't implicate any Burton issues. Remember, Burton only applies to multiple criminal defendants tried jointly. Again, we're under the multiple parties issue here. And then 2, one of the defendants made an out-of-court statement and fails to take the stand in the trial that implicates the co-defendant. If they do take the stand, then the co-defendant can just cross-examine them. We don't have any Sixth Amendment issues. We don't have any Burton issues. We're good there. I think we're going to talk about hearsay exceptions. It needs to be all of 803, all of 804, and I think possibly 807. I think that's hearsay then. No, we'll see what 807 is. But we're going to start with 803. 803.1, present sense impression. That's a statement made while or immediately after receiving an event or condition. Elements, statement made while or immediately after perceiving an event or condition. So 803.2, it's an excited utterance. Startling event or condition, statement relating to event or condition while under stress of the event or condition. Note, excited utterance must be related to the thing that you startled. Illustration of this is someone seeing a car crash and saying, "Oh no, I just got a text from my husband and my dog ran away," while also being startled about the car crash. If you were startled by the car crash, then the excited utterance of the dog running away, that's not going to get in. The excited utterance has to be related to the thing that actually startled you, made you excited. This is because startling event must be the same topic as the statement you are uttering. 8033, state of mind. Above stated in better bullet points. You have a state of mind, emotional, sensory, physical condition. So you have a state of mind. It could be motive, intent, or plan. You have physical condition. Mental feeling, pain, bodily health. I remember how I felt yesterday would be allowed under 803.3, but you can't use it to prove the fact remembered. As in, you can't use it to prove it was hot the other day. You can just say, I remember how I felt yesterday. I felt hot. Elements had to be then existing. I see, I hear, I am. Then existing, internal state. Say, I can't remember feeling sad, since that's not the present sense. It's recalling a past emotion. It has to be then existing, internal state, not a statement of memory or belief. Past tense means it won't qualify as a statement of mind exception. That's what Professor H keeps saying. Past tense means it won't qualify as a state of mind exception. It means I remember how I felt yesterday. So here's a lot of examples. I plan to go to the Circle K later. That's allowed under 803 since it shows a plan right there, state of mind. But you can't say, I went to the Circle K yesterday. That's not allowed since this is a memory. You can't say, I think or believe I might have time to make it to the 7-Eleven today. It's not allowed. It's belief. I feel sad and depressed. It's allowed under 803 since it shows emotional state. Mental feeling. I have bad whiplash. It's allowed. It shows sensation. I feel sick. It's allowed since it shows physical condition. I hate Vince. I want to see him dead. Allowed under 83 since it shows the motive to kill the victim and the speaker hates the victim. I am hearing voices in my head. That's allowed under 803 since it shows current mental sensations. So you can say all these present sense things. You can say, I went to the Circle K yesterday. I think I might have time to make it. Next, we're going to talk about the Hellman Doctrine. The Hellman Doctrine is the idea that past statements by person A about person A's plan can also be used to show person B's plan. Stated another way, a declarant's expressed intent is admissible to prove another person's actions. That's really powerful. It's not a great rule, but it's powerful and can implicate B in some bad things. So an example, I plan on going to the bar with Joan tonight can be used to show the third party, Joan's subsequent actions. On an exam, maybe make a note to say, quote, the Hellman Doctrine isn't settled, but the approach says person A expressed intent to do X with person B is admissible to show person B's subsequent actions. It's an important thing you need to keep in mind. Hellman Doctrine is 100% going to come up on the final. 8034. Statement made for medical diagnosis. Statement that is made for, reasonably pertinent to, in medical diagnosis treatment, medical history, past or present symptoms or sensations, inception of symptoms or sensations, or general cause of symptoms or sensations. The majority rule for SA or abuse cases, and this comes from the 8th Circuit, U.S. versus Iron. SCOTUS hasn't adopted this test yet, but it's a majority in most circuits. The facts. The kid was taken to the hospital for SA injury. These statements, given to doctor, admitted to prove the truth of the matter asserted. The holding, to determine if a statement is made for medical diagnosis or treatment within the scope of 8034. There to be a two-part test. 1, is the declarant's motive in making the statement for diagnosis or treatment, or 2, is it reasonable for a physician to rely on the info in diagnosis or treatment? If yes to both, it falls within the scope of 8034. Attribution of fault when obtaining medical diagnosis. Is attribution of fault or identity considered a general cause of medical treatment? Answer: who hit you and who fired the gun isn't relevant for medical diagnosis or treatment, so its attribution fault isn't allowed under 804 diagnosis. But there are some exceptions. The main question here is the type of statement that would change a doctor's care plan. So identity may change a doctor's care plan if the abuser has access to the patient's home, has continued regular contact with the patient, or acts in a pseudo-medical role like helps them take their medicine or change their bandages or whatever. So as mentioned in this last bullet point list, ongoing access and relationships between the abuser and the patient might change the doctor's plan, so look out for these situations, like an elderly, physically disabled, mentally disabled, and their caretaker, look at child parent, look at domestic violence, look at SA between partners. Moving on to 8035, that's recorded recollection. This applies to something the witness once knew but doesn't remember now. The witness can read this written recollection into the record. Requirements: witness once knew something now but can't remember. Witness made or adopted a record when the memory is still fresh, and record accurately reflects the witness's knowledge. 8036, it's going to be a business record exception. Elements: record of an act, event, condition, opinion, or diagnosis made at or near the time someone with knowledge in the course of regularly conducted activity of a business organization, occupation, or calling. Making a record was a regular practice of that activity. Conditions shown by a qualified witness and source, method, circumstances do not indicate a lack of trustworthiness. For 803.8, this can be government records. Police can't use a statement against the defendant, but in class she said the defendant can use police statements to support their case. That's not the rule, that's just case law. Professor H has told us that in class. Defendant can use police statement to support their case, but police can't use their statement against the defendant. Rule statement, the rule here is that the police can't use police statements against the defendant, but the defendant can use police statement to support their case. The rule is that the police can't use the police statement against the defendant, but the defendant can use the police statement to support their case. That's good, because I guess, under 801, party opponent exception, defendant can't use a police statement, but you can get under 803.8. Good to know. 804A lists 6 situations where a person is, quote, unavailable. Oh, we're moving on to 804. Sorry, that was all the 803 exceptions. And remember, 803 applies whether or not the declarant is available. We're not going to care about that. But for 804, we got to start with 804A analysis, and there's going to be, because you can only use 804 when the declarant isn't available. So you begin with 804A, it's going to give you 6 situations when the declarant would be, considered, quote, unavailable, and thus, you can bring in 804B exceptions. So 804A1, unavailable when privilege exists, like spousal privilege, Fifth Amendment, doctor-patient privilege, etc. Or 2, refuse to testify about the matter in dispute despite a court order doing so. 3, testifies not remembering the matter, regardless of whether the memory failure is genuine or feigned. Note that this happens when a person doesn't remember anything. This wouldn't apply when a person can't remember small, minute details. Rather, they have to testify they just don't remember. 4, they can't testify because of death or infirmity. Obvious. And 5, can't locate or serve the witness through reasonable means. Wrongdoing caveat. But one thing obviously here, if you cause the person to disappear, like, if you kill the witness, so they don't testify against you, you can't benefit from that, from an unavailability witness in 804. So that's going to be the wrongdoing caveat. We think of it as a forfeiture idea, right? You forfeit your right to, you forfeit your right here because you caused the witness's unavailability. So you forfeit the right to have this benefit of this hearsay exception. Now we get to 804B, 1, 2, 3, 4. I think 5 is vacant, 6. So we're going to have 5 exceptions here in 804B, but they're just going to be numbered 1 through 6, and I think we skip 5. 804B1, former testimony. Once the initial bar of 804A, unavailability, is cleared, we can use the exception for 804B for statements that are not excluded by hearsay, beginning with 804B1. The former statement to get under 804B1, we must satisfy these 3 elements. The declarant is unavailable. The witness is testified at a prior trial, hearing, or lawful deposition, and is offered against a party who has an opportunity to cross-examine the witness, and either A, in criminal cases, is the same party, or in civil cases, is the same party or a predecessor in interest. Wait, hold on. We can use the exception 804B for the statements that are not excluded by hearsay. Former statements getting under former testimony. Declarant is unavailable. We know that from 804A. Witness has testified about a prior trial, hearing, or lawful deposition. It's 804B1A. And is offered against a party who had the opportunity to cross-examine the witness and was either, in a criminal case, the same party, or in a civil case, the same party or a predecessor in interest. Lloyd versus American Export Lines gives some guidance on when a second civil party is a predecessor in interest in order to determine what the 2 parties' predecessors in interest look like. Look at, do the 2 parties have a community interest? Do the 2 parties have a similar nucleus of operative fact? Do the 2 parties vindicate similar interests? If yes to all these questions, then more likely they're predecessor of interest. If no to all these questions, more likely not predecessor of interest. 804B1B is where that comes from, I guess. Good to know. 804B2, dying declarations. Again, this only comes in if declarant's unavailable. Or 804A, it's usually 804A4, I guess, isn't it? So it doesn't matter whether the person actually ended up dying. All that matters is the person had an objective belief that their death was imminent. They have the objective belief that their death was imminent, and then they're just like disappear or something. That's like a 804A5 disappearance, I think. Even if they don't die, it's on A4 disappearance or A4 death. If it's they're unavailable because of A5 or A3 or A2, whatever. You can still get in this dying declaration. It doesn't matter if the person actually ended up dying. All that matters is the person had an objective belief that their death was imminent. 804b3, statements against interest. This prevents statements for specifically stated interest in 804b3a. Those statements are proprietary interest, pecuniary interest, invalidates a declarant's claim, or statements that expose the person to criminal or civil liability. So proprietary interest, property interest, pecuniary interest is monetary interest. Invalidates the declarant's claim, i.e. if a person claims they intentionally burned down their own house, and that would invalidate their insurance claim that they might have through their homeowner's insurance, that's going to be a statement against interest. Or statements that, invalidates declarant's claim. It's going to invalidate declarant's claim, invalidate their insurance claim. And then statements that expose person to criminal or civil liability. So a statement that is just embarrassing or shameful, like I admit I have a foot fetish, that does not fall within the scope of 804b3a, so long as it doesn't fit in one of the four interests here, right? Exposure to criminal civil liability, indicates like insurance claim, monetary interest, property interest. So a statement that is embarrassing or shameful, we just said that, right? That's not going to be a statement against interest. It has to be one of the interests stated here in 804b3. Spreading blame to someone else is not a statement against interest. So a statement where you partially admit fault won't necessarily get under 804b3 since it's not specifically against your interest. Rather, you're trying to pass blame off on someone else. Also, Williamson says that we have to break up statements by parts and admit statements against interest and exclude neutral statements that are in the declarant's interest. An example of this is an unavailable declarant said, I had cocaine in the car, but Williamson was the leader. In that case, we would admit part of this statement against the declarant's interest, I had cocaine in the car, and you'd exclude the part that shifts the blame to someone else, like Williamson was the leader. 804b3b requires that in criminal cases, you need corroborating evidence that makes the unavailability declarant statement seem trustworthy. This makes sense because in criminal trial, you have interest to pass blame off to someone else. So the federal rules of evidence say you need something that corroborates and makes this unavailable declarant statement seem trustworthy. I got 804b4. Statements of personal family history. 804b4. Wasn't assigned the reading, wasn't assigned the problem set. It just meant to acknowledge that the statement of your own birthday or whatever, it's not is hearsay, but it's pretty reliable. Not a very profound rule, but just know that it is allowed if anyone tries to say something like their birthday it's hearsay, but when they're testifying, it's an exception. You can be pretty sure that people's birthdays are when they say they are. 804b6, the last one. Yeah, we skipped 5 and we get to 804b6, forfeiture by wrongdoing. 804b6. An opponent is allowed to encourage the witness to testify. Like, I really don't want you to testify, but an opponent is not allowed to wrongfully cause the person to not testify, like with the threat or duress. So threat or duress. Bad things are going to happen if people snitch on me. Notice the opponent has to have a specific intent to prevent the person from testifying. Accidentally killing the witness in a freak accident, like car accident, that doesn't satisfy 804b6. Instead, the opponent would have to have the specific intent to kill or cause that witness to be unavailable. Gray says, if the proponent has to show party had specific intent to cause unavailability of the witness who is now unavailable, then that intent can be transferred to any trial against the person who caused the wrongdoing. So this is a good example. So criminal D killed the witness, not testify against him in criminal case 1. And plaintiff in civil case 2, maybe the surviving family of the victim, plaintiff in civil case 2 can use the witness's statement against the same defendant since the defendant caused the witness's unavailability. And that specific intent to cause unavailability transfers to a different case. So defendant had specific intent for him to not testify in criminal case 1. It's going to transfer to other cases like civil case 2. Next we move on to 807, residual exceptions. That's what 807 is. This is meant to be used rarely. 807 requires the statement to be admitted. If there must be sufficient guarantees of trustworthiness and is more probative than any other evidence the proponent can obtain through reasonable means. Now we got hearsay within hearsay. That's 805. It's when you have hearsay within hearsay, like a business record quoting an eyewitness at the scene. You get the business record to get through that exception, but you got to have eyewitness at the scene saying, I heard the man yell, give me all your money. You would have to do that hearsay analysis separately. Is that for the truth of the matter asserted? I think it's probably for more effect on the listener. So you could get that quote in because it's not TOMA. And then the you get in under the business record exception for 806. So you'd have 2 levels of hearsay. You have to analyze each level on its own, break it up, and then figure out if you can do that. Each one has to have its own reason that it could get in. Impeaching hearsay declarants. 806. First step, scope of the rule. 806 applies to 803, 804, and 802, 803, 804, 801, D2, C through E. But it leaves 806 out. I think that meant to say something else. I don't know. Declarant's statement introduced for non-truth purposes. Oh, notice. This is what 806 leaves out. Declarant's statement introduced for non-truth purposes, like knowledge, notice, effect on listener, verbal acts of independent legal significance, circumstantial evidence, or impeachment. The scope of that rule. Yeah, makes sense. And you can't do 801 D2A or B. This makes sense because you're just impeaching yourself. Think about it. Impeaching other party opponent is just yourself. Or 801 D1. This makes sense because they're already a witness. We already have procedures for impeaching a witness. If hearsay statement is admitted under one of the allowed rules, then the witness' credibility may be attacked and then supported by any evidence that would be admissible for those Article 6 purposes that would have been allowed if the witness testified in person. Also, the court may admit evidence of the declarant's inconsistent statement or conduct even if the declarant doesn't have an opportunity to explain or deny it. This makes sense because 613B says you have to give the witness an opportunity to explain or deny a past inconsistent statement. But the hearsay situation it's often because the declarant isn't available to testify. Thus, this sentence in 806 is included in this rule. You can introduce the hearsay witness's past inconsistent statement even though they aren't there to explain or deny the past inconsistent statement. If the party against whom the statement was admitted calls and declares as a witness, the party may examine the declarant on the statement as if on cross-examination. Next, we got the confrontation clause. Man, I'm long-winded. All right. Confrontation clause. Crawford. The main issue is whether statements were testimonial. If a statement is testimonial, declarant is unavailable to testify, then it might violate the confrontation clause. We're going to have full analysis below. This is only going to apply to criminal cases, right? Because confrontation clause only applies to criminal cases. You can deal when the prosecutor offers hearsay statement against the defendant. It's going to offer where hearsay declarant does not testify in the current trial, because confrontation means you have the right to confront them. If they testify, then we don't have any confrontation clause issues. You have to do it when the statement is testimonial. We're going to talk about that a lot more later. When the criminal defendant didn't have the opportunity to testify in this case, it can still get in if the criminal defendant had the opportunity and similar incentive to cross-examine the person in a past trial. Even when all these elements are met, a testimonial hearsay statement can still get in if it satisfies A, dying declaration, or 2, a forfeiture situation. Examples of testimonial statements. It's going to be affidavits, solemn declarations to establish fact, structured police interrogations, circumstances leading an objective person to conclude that the statement would be available later for trial. Examples of non-testimonial statements. Non-testimonial statements would be business records, co-conspirator statements, casual remarks to an acquaintance, offhand remarks, or dicta and Crawford strongly suggest dying declarations are non-testimonial. That's what we're talking about right up here. Testimonial statement can still get in if it's a dying declaration. Kind of similar there. When something is a declaration, some way to describe a testimonial and non-testimonial statement. A testimonial statement is a solemn declaration of affirmation made for the purpose of establishing or proving a fact. Testimonial statements are made under circumstances which would lead an objective witness reasonably to believe that the statement would be available for use at later trial. Testimonial statements have a primary purpose of creating an out-of-court substitute for trial testimony, and the primary purpose of testimonial statements is to establish or prove past events potentially relevant to a later criminal prosecution. These never raise confrontation clause issues. We talked about earlier. 801D1, by definition, the rule only applies when the witness is on the stand, subject to cross-examination. This rule, 801D1, only applies when there's a witness on the stand subject to cross-examination. In that case, you don't have a confrontation clause issue because they're there and you can cross-examine them. 801 D1AB, that would be the criminal defendant making or adopting their own statement. That has to do with them talking about themselves. 801 D2E, book says status made in furtherance of a conspiracy are not circumstances which would lead a witness to believe the statement will be made for trial later. 803.5, by definition, only happens when the witness is on the stand. So the defendant would be able to cross-examine them. 804B1, by definition, only happens when the criminal has an opportunity to cross-examine in the past case. 804B2, this is founding era exception. Oh yeah, founding era exception, forfeiture situation, I guess, right? 804B6 is a founding era exception of forfeiture. This is a founding era exception dying declaration. Got it. Usually don't raise confrontation clause issue. 803.4, this is because a person is usually making a statement to provide medical care, not to accuse someone of future criminal litigation, but the statement of abuser for purpose of treating victim would be testimonial. 803.6, usually not made for the purpose of being used in court. But if business record is created in anticipation of litigation, then it might raise a confrontation clause issue if you're creating this business record in anticipation of litigation. 803.7, absence of a record isn't a statement, but to satisfy a confrontation clause issue in the Constitution, a witness participating in the search must testify live about the absence of the record. 803.10, same as above. 803.17, market reports usually aren't testimonial, but law enforcement publishing lists that include testimonial evidence might raise confrontation clause issues. 803.18, learned treatises aren't created to convict a specific defendant, but you could think of an unusual case law where law enforcement agency might publish a book documenting crimes of a person, and that might raise confrontation clause issues. This often does raise confrontation clause issues. 803.1 and 2, presence and suppression of excited utterance. No confrontation clause problem when made to friends to get immediate aid during an emergency, but it has 6A problems when it's made to law enforcement for primary purpose of creating prosecution evidence. I don't think we talk about it, but just so we know, if it's like ongoing emergency, it's less testimonial. If it's like the emergency is ended, it's more testimonial, right? If it's an ongoing emergency, you're not doing it to like, think about the case later. You're doing it because you want the bad guy stopped. So if it's an ongoing emergency, it's gonna be less testimonial. If the emergency is more ended, it's gonna be more testimonial. 803.3, same as above. 803.8, government records, many public records are testimonial. 803.16, statement does not lose testimonial nature just because they are ancient. 804B3, statement made to private parties are probably not testimonial, but confessions of crime might raise 6A problems. 807, grand jury statements are testimonial after Crawford. And we got some case law we gotta go through. Crawford. A criminal defendant has the right to cross-examine any person who makes a testimonial statement against him. Davis v. Washington. Statements are non-testimonial when made in the course of police interrogations, objectively indicating that the primary purpose of the interrogation is to enable police to assist in an emergency. Okay, Washington. That's what I was talking about earlier. About it's more ending an emergency, it's really not really testimonial, and it's objectively indicating the primary purpose of that. Hammond. Emergency ended, so statements of police are not testimonial. I think I got that wrong. So emergency ended, so statements to police are testimonial. I don't know why I got that wrong. Brian did a good job of giving us a good way to analyze whether a statement during ongoing emergency is testimonial or non-testimonial. Rule of statement from Brian. When deciding whether something is an ongoing emergency, we have to look at both the declarants and the officer. Look at what the declarant believed was an ongoing emergency. Look what the officer were trying to stop the emergency, or were they trying to figure out who did it so they could make arrests and charge the person who caused the emergency. Bowl coming. Lab reports are testimonial. It can get in under business record exceptions as hearsay, exceptions in 803.6, but it is still testimonial. Thus, you can't have a surrogate or keeper of the records or person familiar with this process testify, which is what is described in 803.6. Rather, you must have the actual lab technician there to testify with it in order to get the prosecutor to comply with 6A, Confrontation Clause concerns. Next, you got Williams, a lab technician who compared two samples and said it was a match. But court said that's not testimonial, since the technician wasn't doing this to identify a suspect, rather they were just seeing if the samples matched. Weird. So how do you harmonize Bullcoming-Williams? Bullcoming is having a suspect in mind is what makes it testimonial, since you're trying to find someone. Williams, just a general test without a specific suspect in mind makes it non-testimonial. Clark, child abuse situation. In that case, victim's statement to the doctor about who the abuser is might not be testimonial. Hempful. Facts are, the child died as a bystander shootout. Investigators knew Morris was at the scene and executed a search warrant to search his home. Found a cartridge and the murder weapon, but didn't find the gun. Found a cartridge for the murder weapon, or what matched the murder weapon, but didn't find the gun. Morse charged. First trial was a mistrial. Second trial, Morse took plea where he admitted he had the weapon other than 9mm. Hemphill later charged with murder of that victim. Hemphill's defense was that Morris was the shooter. Prosecutor sought to use Morris' statement from a plea deal allocution that he didn't have a 9mm. Morris didn't satisfy Fifth Amendment. Thus, Morris' past statement during guilty allocution were out-of-court statements, and Morris didn't testify. Fifth Amendment. Thus, there are Sixth Amendment concerns for the current defendant, Hemphill. Holding. The defendant does not waive confrontation clause just because they're raising a defense that is based on out-of-court statement. So the confrontation clause analysis. Is the out-of-court statement offered against the criminal defendant? If yes, is the statement offered for the truth of the matter asserted? No, then it's admissible under confrontation clause, but double check admissibility under the hearsay rule. So if Toma, so then get under hearsay. Because not hearsay. But what if it is offered for Toma? Is the statement admissible under party opponent, dying declaration, or forfeiture exceptions? If yes, it's admissible. Is statement, but if not, if statement testimonial. If not, then we're done, right? If it's like emergency or whatever. If yes, if the declaration is available at trial. If yes, then it's admissible. If no, does the defendant have a prior opportunity to cross-examine the declarant about the statement? If they did, might be admissible. I think it's a 1D1, maybe a 1D2. I don't remember. But if not, it's inadmissible under the confrontation clause. But is the out-of-court statement offered against a criminal defendant? No. Civil case or statement offered against the government in a criminal case, then it's admissible. That's what we got.